Welcome back to another Loud Little Ducky video. Today, before we get into Greg Gillespie and Owen's case anymore and put out part 3, I want to go over the abortion coercion laws in Arizona. And forced abortion is not a choice, obviously, but this is what Owen says Gillespie did. So let's see if he fits in any of these categories, because they were argued in his hearings on these facts. This was the law that they argued from. So let's take a look at it. So Arizona Statute 362153, informed consent requires information, website, signage violation, civil relief, statute of limitations. A. An abortion shall not be performed or induced without the voluntary and informed consent of the woman whom the abortion is performed or induced, except in the case of a medical emergency and in addition to other requirements of this chapter. Consent to abortion is voluntarily and informed only if all of the following are true. So basically, if the woman is doing it voluntarily and with informed consent, she goes and gets it done. She signs the paperwork herself, gets the pills herself, takes them herself. Nobody's slipping them into her drinks. Nobody's, holding her down, knocking her out with drugs, and then just taking a baby. There's lots of cases of that that are crazy out there. But it has to be voluntarily and informed consent of the woman whom the abortion is going to be done on. So, number 1, at least 24 hours before the abortion, the physician who is to perform the abortion or the referring physician has informed the woman, orally and in person, of A. the name of the physician who will be performing the abortion. Well, she would know that. B. the nature of the proposed procedure or treatment. She would also know that. C. the immediate and long-term medical risk associated with the procedure that a reasonable patient would consider material to the decision of whether or not to undergo that abortion. D. alternatives to the procedure or treatment that a reasonable patient would consider material to the decision of whether or not to undergo the abortion. So they need to know about this and other ways to undergo abortions. The probable gestation age of the unborn child at the time of the abortion is to be performed. So they should know the gestational age, which they would do that with a sonogram. F. the probable anatomical and physiological characteristics of the unborn child at the time of the abortion is to be performed. G. the medical risk associated with carrying the child to term. So, if there are risks associated with carrying the child to term, that's one. But they need to know, and the people doing the abortion, and I'm guessing the mother, needs to know the gestational age of that unborn child. And you need to verify that based on tests done before the procedure. Because there are weeks that if that child is actually that far along in, that these abortions can't be performed. So they have to know the gestational age. They can't just go off of what you tell them, and you could be wrong. So they need to verify it with by scientific means. They also need to know certain characteristics and physiological, anatomy and physiological characteristics of the unborn child at the time. So they need to know kind of what the baby looks like, and stuff like that. They have to document this stuff. Like, there's so much that has to go into abortions, especially because they are so controversial. And I mean, they have to follow these to a T, or they would not be able to continue doing this stuff. And you can bet that the state and everybody is making sure that everything's being done the way it's supposed to do. Because if they can get rid of all these abortion places, they will. I don't know about in Arizona, but in a lot of other states, not everybody agrees to the right of abortion. But we're not going over the rights here. But we need to understand that they're making sure everybody's following the rules, and people have a close eye on them. Number 2, at least 24 hours before the abortion, the physician who is to perform the abortion, the referring physician or qualified physician, physician's assistant, nurse, pathologist, or licensed behavioral health professional to whom the responsibility has been delegated by either a physician, has informed the woman orally and in person that. So these are the things that 24 hours prior that you have to know. Medical assistant benefits may be available for prenatal care, childbirth, and neonatal care. The father of the unborn child is liable to assist in the support of the child, even if he has offered to pay for the abortion. In the case of ARPing or incest, this information may be omitted. Public and private agencies and services are available to assist the woman during her pregnancy and after the birth of her child if she chooses not to have an abortion, whether she chooses to keep the child or place the child up for adoption. It is unlawful for any person to coerce a woman to undergo an abortion. Now, does that mean all these people that it's listed in number 2? Or is it anybody in the world? E. The woman is free to withhold or withdraw her consent to the abortion at any time without affecting her right to future care or treatment and without the loss of any state or federally funded benefits to which she might otherwise be entitled. F. The Department of Health Services maintains a website that describes the unborn child and lists the agencies that offer alternatives to abortions. G. The woman has the right to review the website and that a printed copy of the materials on the website will be provided to her free of charge if she chooses to review these materials. H. In case of a surgical abortion, the woman has the right to determine final disposition of bodily remains and to be informed of the available options for locations and methods for disposition of bodily remains. So she needs to know all this. And so Statute 1 and Statute 2 both say 24 hours before. So if Owens has gone into these Planned Parenthood places, they are not doing pill abortions or surgical abortions in one day. You can go in, get your consultation, find all this information out, and then the next day, after you, because it's a serious decision and they want to make sure you have had at least 24 hours to think about all this stuff, you can then come back and this stuff can be done. But 24 hours, all this stuff has to be done. And you can't know all this stuff if you just walk. It's like if you just walk in there and be like, all right, take this thing out of me, get rid of this thing. Okay, bye. It's not a one-stop shop. You have to go back, because they need you to think about it before you do. Make sure you're weighing all this. Make sure now that you have all of this information, is this really what you want to do? Because is there some decisions in there that you didn't realize you were going to have to make? Are there some things that you're going to have to do that you didn't realize you were going to have to do? So it's something that you really need to take a look at. Number 3, the information in paragraph 1 and 2 of this subsection is provided to the woman individually and in a private room to protect her privacy and to ensure that the information focuses on her individual circumstances and that she has adequate opportunity to ask questions. 4. The woman certifies in writing before the abortion that the information required to be provided pursuant to paragraphs 1 and 2 of this subsection has been provided. So she has to sign a piece of paper that says she's known about this for 24 hours. 5. In the case of a surgical abortion, if the woman desires to exercise her right to determine final disposition of bodily remains, the woman indicates in writing her choice for the location and the method of the final disposition of the bodily remains. B. If a woman has taken mifepristone as part of a 2-drug regimen to terminate her pregnancy, has not yet taken the second drug, and consults an abortion clinic questioning her decision to terminate her pregnancy or seeking information regarding the health of her fetus or the effectiveness of the mifepristone alone to terminate the pregnancy, the abortion clinic staff shall inform the woman that the use of the mifepristone alone to end the pregnancy is not always effective and that she should immediately consult a physician if she would like more information. So it doesn't always work. Or if you've taken one but you haven't taken the second one, she's got to be well informed. C. If an medical emergency compels the performance of an abortion, the physician shall inform the woman before the abortion is possible of the medical indications supporting the physician's judgment that an abortion is necessary to avert the woman's death or to avert substantial and irreversible impairment of the major bodily functions. D. The Department of Health and Services shall establish and shall annually update a website that includes a link to a printable version of all the materials listed on the website. The materials must be written in an easily understood manner and printed in a typeface that is largely enough to be clearly legible. The website must include all of the following materials. Number 1, information that is organized geographically by location and that is designed to inform the women about public and private agencies and services that are available to assist women through the pregnancy, at childbirth, and while her child is dependent, including adoption agencies. The materials shall include a comprehensive list of agencies, a description of the services they offer, and the manner in which these agencies may be contacted, including the agency's telephone numbers and website addresses. Very interesting. So, Planned Parenthood and everybody else has to have all that information on their website. 2. Information on the availability of medical assistant benefits for prenatal care, childbirth, and neonatal care. 3. A statement that is unlawful for any person to coerce a woman to undergo an abortion. So they have to make sure that it says that a person cannot coerce you into having an abortion. Like not the clinic, not any of the doctors, nothing. 4. A statement that any physician who performs an abortion on a woman without obtaining the woman's voluntarily and informed consent or without affording her private medical consultation may be liable to the woman for damages in a civil action. Number 5. A statement that the father of a child is liable to assist in the support of the child, even if the father was offered to pay for an abortion and the law allows adoptive parents to pay costs of prenatal care, childbirth, and neonatal care. A statement that the father of a child is liable to assist in the support of that child, even if the father has offered to pay for the abortion. That is interesting. I guess that's nice. 6. Information that is designed to inform the women of the probable anatomical and physiological characteristics of the unborn child at 2 weeks gestation increments from fertilization to full term, including pictures or drawings representing the development of the unborn children at 2-week gestational increments and any relevant information of the possibility of the unborn child's survival. The pictures or drawings must contain the dimensions of the unborn child and must be realistic and appropriate for each stage of the pregnancy. The information provided pursuant to this paragraph must be objective, non-judgmental, and designed to convey only accurate scientific information about the unborn child at the various gestational ages. 7. objective information that describes the methods of abortion procedures commonly employed, the medical risks commonly associated with each procedure, the possible detrimental psychological effects of abortion, and the medical risks commonly associated with carrying a child to term. So they want all this stuff, listed, all the medical risks, the possible detrimental psychological effects, depression, things like that, the grief that goes with it, regret, all of that stuff. You need to inform the woman seeking the abortion of these things, because she can't just do that afterwards. I think a lot of them are common sense, but there may be some that we don't think about. 8. Information explain the efficacy of mifepristone taken alone without a follow-up drug as part of the 2-drug regimen to terminate pregnancy, and advising women to immediately contact a physician if a woman has taken only mifepristone and questions her decision to terminate her pregnancy or seeks information regarding the health of her fetus. So this, without the follow-up. So, they have to inform everything. The woman has to be informed, and she has to do it voluntarily, and she signs the papers to do all of this stuff. And it says that you're voluntarily doing this yourself, that you agree that you are doing this with informed consent and voluntarily, that you are not coerced into this and you're not forced into this. When you sign that paper, that's what you state. E. An individual who is not a physician shall not perform a surgical abortion. And this should be a no-brainer, like, duh. But there's some crazies out there. So, we know that nobody gave Owens an abortion that wasn't a doctor. Like, none of the exes did this to her. So, she wasn't coerced or forced in that way. So, E does not apply to the Owens situation. F. A person shall not write or communicate a prescription for drug or drugs to induce an abortion or require or obtain payment for service provided to a patient who has inquired about an abortion or scheduled an abortion until 24-hour reflection period required by subsection A of this section expires. So you can't even pay to get your abortion until 24 hours later. So walking in, doing all this, and paying for it on one day is not how abortions are done. G. A person shall not intimidate or coerce in any way any person to obtain an abortion. A parent, a guardian, or any other person shall not coerce a minor to obtain an abortion. If a minor is denied financial support by the minor's parents, guardians, or custodian due to the minor's refusal to have an abortion performed, the minor is deemed emancipated for the purposes of eligibility for public assistance benefits, except that the emancipated minor may not use these benefits to obtain an abortion. So, not even your parents or your guardians can force you into having an abortion. I will link a video that I have on a different channel that I kind of go over some of this stuff in regards to teen pregnancy, if anybody wants to check that out. It's a touchy subject, but it goes through all the different things. But nobody can force you. They cannot go in there and make you do this. H. An abortion clinic as defined in section 36449.01 shall conspicuously post signs that are visible to all entering the abortion clinic. They are clearly readable and state that it is unlawful for any person to force a woman to have an abortion, and a woman who is being forced to have an abortion has the right to contact any local or state law enforcement or social service agency to receive protection from any actual or threatened physical, emotional, or psychological abuse, the sign shall be posted in the waiting room, consultation rooms, and procedure rooms. So this is saying that a person cannot force somebody. This needs to be done of her own free will. A person shall not require a woman to obtain an abortion as a provision in the contract or as a condition of employment. J, a physician who knowingly violates this section commits an act of unprofessional conduct is subject to license suspension, revocation pursuant to Title 32, Chapter 13 or 17. K, in addition to these other remedies available under the common or statutory law of the state, any of the following may file a civil action to obtain appropriate relief for a violation of this section. Number 1, a woman on whom an abortion has been performed without her informed consent as required by this section. Well, she signed the consent form. She went and got the drugs. 2, the father of the unborn child, if the father was married to the mother at the time she received the abortion, unless the pregnancy resulted from the plaintiff's criminal conduct, which it didn't here. 3, a maternal grandparent of the unborn child, if the mother was not at least 18 years of age at the time of the abortion, unless the pregnancy resulted from the plaintiff's criminal conduct. That obviously does not apply in the case that we're looking at. L, a civil action filed pursuant to subsection K of this section shall be brought in the Superior Court in the county in which the woman on whom the abortion was performed resides, and may be based on a claim that failure to obtain informed consent was a result of simple negligence, gross negligence, wantonness, willfulness, intent, or any other legal standard of care. Relief pursuant to subsection K of this section includes the following. Number 1, money damages for all psychological, emotional, and physical injuries resulting from the violation of this section. 2, statutory damages in the amount equal to $5,000 or 3 times the cost of the abortion, whichever is greater. 3, reasonable attorney's fees and costs. M, a civil action brought pursuant to this section must be initiated within 6 years after the violation occurred, which it was done in that amount of time. So damages in the amount equal to $5,000 or 3 times the cost of the abortion. So if the abortion was $5,000 and you can times that by 3 and get $15,000, and you could also get reasonable attorney's fees. Not this high amount that Owens was trying to sue for. And we'll discuss a little bit more about it in the Owens v. Gillespie, Part 3. But I wanted us to know what the law states, so that when we're going over this stuff, we have an informed knowledge of what these attorneys and stuff are saying. That is it for me. Like, subscribe, and I will see you in the next one.